morning, Mr. Moser.
Good morning. Lord and Lady, I'm leading Mr. Philip Wolfe, KC, and Mr. Oliver Jackson. My learned friend, Mr. Timothy KC, appears for MasterCard, leading Ms. Naina Patel, and my learned friend, Mr. Simon Sorcido, KC, appears for Visa, leading Mr. Tim Johnston. You should have 8.
You may need to speak up a bit, Mr. Moser.
I'm sorry.
I can't hear you very well, and there's noise outside, so
yes.
Keep our voices up.
I will be louder.
Thank you.
There should be 8 regular authorities bundles, a core bundle, and a supplementary documents bundle. There is also a supplementary authorities bundle, which I'm afraid only appeared in hard copy this morning, but should have been available at least electronically yesterday, and that is therefore a 9th bundle. I don't know how it's labelled in hard copy, I'm afraid.
Supplementary authorities bundle.
I'm grateful. This is an appeal in which the Competition Appeal Tribunal granted permission to appeal against its own decision on 4 grounds. The central plank of the decision below was that the post-Brexit European Court of Justice judgment in Volvo was not authority for the proposition, as a matter of EU law, was not authority for the proposition that limitation periods in competition law claims cannot begin to run until the infringement has ceased, which the CAT called the cessation requirement. And I will sometimes say post-Brexit, and sometimes I will say post-IPCD or similar. If I do that, then please accept I mean the same thing for present purposes.
Now, Mr. Moser,
yes.
I don't want to derail this, but I think you should know the court's concern. We've done a lot of reading.
Yes.
So I think we understand the issues. At the moment, I'll be completely blunt, you are going to have a bit of an uphill struggle to persuade us that 4 of their lordships in the Supreme Court should be disagreed with by us at this level when they have just heard argument, analysed the decision of the CAT below, and had a big argument amongst themselves as to which is the right approach, and decided that the right approach is the one that they plumped for. So, of course, we're not going to stop you. Our minds are open. We have absolutely the ability to disagree with the Supreme Court if we thought it was useful. But at the moment, for my part, I can't see why it's useful. If you lose that point here and go to the Supreme Court, no doubt you'll be very persuasive in explaining why they should go through the whole thing again, just having done it. I know there's lots of arguments about obiter, dicta, and some lovely case about nuisance I see this morning came in, all of which I'm sure we will be fated with. But, as I say, it will be an uphill struggle, and you may meet a little impatience after a lengthy time addressing that argument. So you're going to have to come out with some fairly good, strong points at the beginning. The second point is that assuming we were minded to pay respect to our Supreme Court and say that what they said should be followed here today, we then moved really to issue 3. And issue 3 is the question, assuming we are to have regard to Eureka and Volvo, and assuming it means what you say it means, we have run into a further problem of precedent called Arcadia. And one might have thought that Arcadia didn't matter because it was all about something different and the point wasn't raised. But unfortunately, Arcadia seems to be all about the same thing, and the point was raised. And for my part, again, if Lipton is to be followed, I don't see how we can say that having regard to a European court authority post-Brexit, however strong that authority might be, and however it might chime with our own 2017 new legislation, we should disregard and feel ourselves not bound by Arcadia. Again, it's really a matter for you to go off to the Supreme Court and say, this is all totally wrong, Arcadia was wrong, the Court of Appeal shouldn't have followed it anyway, and plague on their houses. Now, if that's right, this is a very short case, and really you're slightly in the wrong place. So I'm just putting those points to you because at the moment none of us, having looked at it this morning, see a very easy route beyond those 2 points. Now, we're very willing to listen to anything you might want to say. We've got 2.5 days, but it seems a long time to get over those hurdles. It might be you'll have done it by 10 o'clock, 11 o'clock, or not, as the case may be.
My lord, yes.
I think you mean, my lord, no.
That is implied. Here's what I propose to do.
Yeah.
Because I, too, have been doing some thinking along those lines, and indeed indicated it in part to my learned friend, Mr. Otti, yesterday. I see entirely where your lordship is coming from in relation to Lipton. And that deals mainly with our ground 2, of course, which is Volvo binding. And I've read attentively what my learned friend Mr. Otti has said in his skeleton argument about Lipton, which is that whatever else you may say about it, it seems that all of them, all of their lordships, the justices, treated the EU authority they had to deal with, TAP Portugal, as not being binding, and that is not obiter, that is ratio, in Lipton. And so, if for no other reason, for that reason, I propose largely to follow the course on Lipton that your lordship has outlined, which is that in ways that I will explain, I will want to look at it for other aspects, but in ways that I will explain, I take the point that it is a matter to be reserved for the Supreme Court, if it gets there, whether a post-implementation day CJEU authority is binding on this court in relation to a pre-implementation day matter. That is mainly ground 2, however, because ground 1 goes to whether the cessation requirement is part of EU law, and that is to be found in Volvo and Eureka, to which one can have regard. And I'll come back to what it means to have regard to these things. The second hurdle that I must surmount is Arcadia. Now, in relation to Arcadia, I am going to attempt to show why we say it is to be distinguished. And if Arcadia cannot be distinguished, I have a liberating thought to put to the court, and the liberating thought is that because we are dealing with EU law under the Withdrawal Act, the EUA 2018, this court has the ability, and indeed I would say must, disregard Arcadia because it gives way to the supreme EU law as introduced into English law by the Act. So I say that if...
Sorry, just say that again.
Well,
your liberating thought is what?
The liberating thought is that you are able to get round Arcadia because we are, once we've had regard, if you were to have regard under Section 6 of the Act to Eureka and Volvo, then we are dealing with EU law under Section 4 and or 5 of the Act. And so we have supremacy active in order to get round Arcadia. And I'll explain that when I come to relevant grounds. So I would like to approach this, if I may, by first making some introductory submissions about the claim of the decision below, including what Lipton brings. Then I'll address ground one as to the cessation requirement being part of EU law. Thirdly, I've largely advertised what I'm going to say about ground two, but I'm going to address that. And then fourthly, I'll address ground three, which is what I just dealt with in relation to Arcadia. That is why even if Volvo and Eureka are not binding in this case, the UK court should nonetheless have regard to them. And then what does that mean? It means apply it as saved EU law. And also have regard...
It seems to me that effectively gives them binding effect. It's not having regard to them, it's giving binding effect to them, because that's the only way in which you could say that this court, applying the principles in Young and Bristol Aeroplane, should effectively disregard what would otherwise be a binding decision of our own court. If it's simply a question of having regard to a European case, it can't possibly trump a decision which is binding on us as a matter of the doctrine of precedent. Just, it seems, well, by all means argue it, Mr. Moser, but speaking for myself, I can't see the point.
Well, my argument is going to be that there's a difference between the doctrine of precedent and the correct interpretation of the law. And so, whilst it's not a precedent, what does having regard to it mean? Having regard to it under section 6.2 in this...
Just say that again, because I need to think about it. There's a difference between the doctrine of precedent and a binding and what?
And
correct interpretation of the law.
The correct interpretation of the law.
You
So
mean correct interpretation of the 2018 Act?
Yes.
I think you're referring to sections 5 and 6 in particular.
Yes.
Aren't you?
I mean,
Yes.
if we go straight there, because it's in Authorities Bundle 1 at tab 12. If we look at page 190, we see there section 6 of the European Union Withdrawal Act 2018, which is your statutory power to look at post-implementation day authority. And section 6.2 is subject to this, and subsection 3 to 6, a court or tribunal may have regard to anything done on or after IP completion day by the European Court, another EU entity, or the EU, so far as it is relevant to any matter before the court or tribunal. And that is, as it were, your way in to post-IPCD authority. It is what has effectively replaced Section 3 of the old European Communities Act, which said that you're bound by EU court cases. But that is a matter of precedent. It's not a precedent where you can have regard to it. What does that mean? Once you are in and you have regard to it, I say you look back at the previous sections of the Withdrawal Act, in particular sections 4 and 5, and we look at section 4 on page 185, saving for rights, etc. Any rights, powers, liabilities, obligations, restrictions, remedies and procedures which immediately before IP completion day are recognised and available in domestic law.
Sorry, you're a bit ahead of me. You're on
But
section...
if
185,
185,
section 4.
Yeah, okay. Any rights, powers, liabilities, yeah.
any rights, powers, liabilities, obligations, restrictions, remedies and procedures immediately before IPCD, recognised and available in domestic law by virtue of section 2, and are enforced, allowed and followed accordingly, continue on and after IPCD to be recognised and available in domestic law and to be enforced, allowed and followed accordingly. Now we will say that the general principle of effectiveness is one of those, and for the sake of completeness, so is supremacy, which immediately before IP completion day allowed the court to abrogate the domestic laws of precedent, as we saw in Byrne, my Lord Justice Flo's judgment. If we then turn over to page 187, we may not even need it for this purpose, but in addition, it is made express at 5.2 that the principle of supremacy of EU law continues to apply on or after IP completion day so far as relevant to the interpretation, disapplication or quashing of any enactment or rule of law passed or made before IP completion day. And the rule of law passed or made before IP completion day would include judge-made law, such as Arcadia. And so, for my Lord Justice Flo, we're not saying that the court is bound by Eureka, but we are saying that if you have regard and choose to follow it, then it is EU law, it is saved by Section 4 of the European Union law, and you are not bound to follow Arcadia by reason both of Section 4.1 and Section 5.2.
But you started that by saying that if you choose to follow it, the initial question is whether we're free to make that choice.
Well, one wonders, if I can ask rhetorically, how this is to work if you are not free to make that choice. Because if you're going to have regard to Eureka, say, then with great respect, the position advanced by my learned friend, Visa, I submit, makes no sense under the statute, because you either have to accept that you should have regard to Eureka, but even if you consider that Eureka correctly states the position in EU law, it should nonetheless be the case that you're bound by Arcadia to reach the contrary conclusion, in which case, what is the point of having regard? Or we would be contending that the power in Section 6.2 to have regard to CJEU decisions only applies where the court is not bound on the point by existing authority. So that would be a limitation of 6.2 that isn't there. And I submit there's no need to read any such limitation into 6.2 of the Withdrawal Act 2018. So that's how we say that works, in order to give the statute the purposive interpretation that it requires. What is the point of finding what the correct EU law is, and for the purposes of the 2018 Act, knowing that it has supremacy, and having the powers that you had immediately before IP completion date, including departing from English law where necessary. What is the point of all of that if you are, having had regard to it, not able to apply it, or indeed not able to apply it if there is a previous...
Isn't there a point about finality of litigation? Arcadia decided a point of EU law, not appealed to the Court of Justice. And that was the law in this jurisdiction. And even if later the Court of Justice decides that was not EU law, that stands as EU law for good and all. Certainly in this case, but because we left the EU, forever. And what I don't understand is how we can say that decision as to EU law, not appealed, is somehow, or can somehow be changed. Because if you test it at any stage between 20, whenever it was,
15.
16, 15, and 2022, that was the law. And it bound us. So why doesn't it bind us thereafter?
Well, I say that it does no injury to the principle of legal certainty if a subsequent case clarifies the law and it turns out that the law, not from that time, but at all material times, was different. We know that judgments of the European Court of Justice apply what they call ex tunc, so from the beginning of time, as it were. When Eureka...
Ex tunc, I've always wondered about that, means from the beginning of time.
Well, that's my paraphrase, but ex nunc is from now, ex tunc is from then, broadly speaking.
Can we use English?
Yes.
Really helpful.
Ab initio,
Yeah,
to use a good English phrase.
really, try English. I mean, it's very, I find ex tunc and ex nunc very confusing. Anyway, I know what you mean.
Yes.
For this purpose, but I still do not see how, in the context of Brexit, we can suddenly see the law clearly. It's not a question of clarification or refinement. It's a question of an outright change. And I just don't see how we can suddenly disregard what has been said to be the law as to our limitation provisions and the compliance of our limitation regime with principles of EU law, simply because after we've left the EU, a decision to which we may have regard, it is the words are may have regard, whereas doctrine of precedent says we must follow our own decisions.
That's why I'm trying to draw the distinction between precedent and what the law is. So once it's clear you may have regard to an EU law.
But it comes to the same thing, Mr. Moser, because what you're really saying on analysis is because EU law, because Eureka, you say, has fixed what EU law is from the beginning of time, Arcadia is wrongly decided because Arcadia decided something else. But that is exactly, that runs you straight into the fact that Arcadia is a binding decision of this court, which is binding on us. So you may very well be right when you get to the Supreme Court. You might have an argument about it. I can see that. There might be all sorts of other obstacles in your way, but at the moment I can't see how, merely because Eureka establishes what EU law is, we are entitled to say that a decision of this court, which was at the time when it was given was not appealed to the Supreme Court, was wrongly decided. Well, that runs a coach and horses through the whole doctrine of precedent.
It's true that it wasn't appealed to the Supreme Court, but of course Arcadia did not involve our clients. And so,
well, it doesn't matter who is involved. It's binding. It's a binding decision on this particular point of law.
On the question of finality, I respectfully submit it does at least make a nuance of a difference because we weren't involved in that. On the question of precedent, it is just a point, in my respectful submission, of the ongoing evolution of law. It's no different to Anns and Merton Borough Council or other cases where the law finds it has taken a wrong turning and subsequently that is put right. And I say, and this is what I sense is the main point of disagreement between us, if that's the right word, and I say that the EUA 2018 powers are wide enough to give this court the power to depart from a decision of the Court of Appeal where it turns out that it was wrongly decided in the sense that it turns out it was not deciding EU law as it should be interpreted, which we now see in Eureka. And I don't know how best to approach this, because of course there's a certain amount to say before one gets to that point, but I wonder whether it might be best done if I addressed Arcadia straight away in the way that I want to address it, which I'm afraid involves
Looking at it.
looking at it.
So that's all right.
And also, I'm going to do, well, I'm going to do two things. First, I'm going to try and distinguish Arcadia. If I can't distinguish it, I'm going to return to, as it were, my liberating thought, which I can see hasn't so far proved tremendously liberating.
Well, it hasn't liberated us, anyway.
I mean, the EU law case that I was thinking of in
Yes.
making my finality point is Capfua,
Yes,
which you're probably familiar with. I don't know if it's in the bundle, but
I don't think so.
okay. But it's paragraphs 19 to 21 of Capfua that say basically, even if a domestic law decision has decided EU law wrongly, it stands. You can't, just because it changes later, you can't ignore that decision.
But we
If
do
it's not referred, which it wasn't here.
we do have also in the bundle various authorities that show that national courts ought not to follow even their own higher courts when they have made a ruling on EU law that is contrary to the.
That's of course true, because that's when EU law changes, because you're still bound by it. But your point in that is section 6.2 and 4.2 and 5.2.
Yes.
Okay, all right, well let's look at Arcadia.
Arcadia is where?
So Arcadia is, if you give me a moment.
Tab 40.
Yes, it is. So there are two Arcadia decisions in the bundle now. There is the Court of Appeal decision. There's also the High Court decision of Mr. Justice Simon, which is in Supplementary Authority Bundle tab 5. And I'd like to go to each of them in turn. For my first submission.
Sorry, you're now wanting to go to the first Arcadia.
The
to
first Arcadia.
First instance.
Yes,
Right.
which I say is helpful. And I'm sorry if this is going to take a little longer, but
We've got all the time in the world.
it's plainly a central point. So I propose to take it in turn.
Yes, so
So what's, just by way of introduction, what I'm going to say is that even as a matter of domestic law, Arcadia is not binding authority against us on ground 3. And I'm going to say that for two reasons. The first reason is that it does not address the appellant's point in this appeal, in my submission, namely that the EU principle of effectiveness mandates, and has always mandated, the cessation requirement. And that includes the period while EU law was in force in the UK.
sorry, I'm getting disturbed by this
Yes.
wailing outside. Can you? It's an important submission. I want to get it down correctly. Can you just speak up a tiny bit and
Yes,
repeat it? Arcadia is not binding because.
because, first, the ratio of Arcadia does not address the appellant's point in this appeal. Quite specifically, that the EU principle of effectiveness mandates, and has always mandated, the cessation requirement. So in Arcadia, the court was dealing with a very different argument concerning the knowledge required to ground a claim for the purposes of section 32(1)(b of the Limitation Act 1980. And I say Arcadia can be distinguished so that the ways that are open for you to have regard to Volvo and Eureka, in a way that I have yet to explain, but I think we all know what I mean when I talk about Eureka and the cessation requirement.
Yeah.
My second point is, even if my first point is wrong, and the ratio of Arcadia does cover the appellant's submissions in this case, then in a way that I've already explained, that's overtaken by sections 4, 5 and 6 of the EUA 2018. So that as a matter of UK law, again, the Court of Appeal is not bound by Arcadia. So turning then to the High Court decision, which is in Supplementary Bundle tab 5, it was handed down in October 2014, and it concerned claims by Arcadia, so that's Topshop and so on, and others against Visa. It starts at page 136. And going somewhat briskly at paragraphs 7 and 8, we see that Visa applied for a strikeout summary judgment for all claims for damages outside of the 6-year limitation period. That's paragraph 9. The claimants relied on 2 provisions of the Limitation Act. First, section 32(1)(b) and section 32(2). And at paragraph 10, the final sentence, we see the card schemes case was that all facts relevant to the right of action were in the public domain, so the claim should be confined to causes of action which arose after the limitation dates, so 6 years prior to the issue. And that's the issue before the High Court, entirely concerned with knowledge. And Mr. Justice Simon then reasons as follows. He refers to the pleadings at 11 to 14. At 16 to 22, he sets out the legal principles governing damages claims for Article 101 infringements and strikeout. And at 23 to 30, sets out the domestic UK cases on section 32. Paragraphs 31 to 39 address various points made by the claimants about the standard of pleading, not relevant to this appeal. And paragraphs 40 to 43 set out the damages directive. Now, the damages directive had not yet come into effect at this point. That is in paragraph 41. First sentence, Mr. Randolph pointed out that the recently corrected directive will be adopted following formal confirmation by the Council, which is expected shortly. Will then come into force as a matter of English law within 2 years. In effect, what the claimant submitted was that the provisions of that directive should be given retrospective effect by the High Court. And we see that as well in paragraph 41, first and second sentence. In these circumstances, in the second sentence, he submitted, Mr. Randolph, it would be highly unsatisfactory to strike out the claim in the present case insofar as it relates to the period before the limitation date, since if it was struck out now, it could be resurrected later, when the directive came into force. Now, Mr. Justice Simon rejected that submission at paragraph 42, saying the answer was contained in Article 22 of the directive, which provided that the substantive provisions did not apply retroactively, and at paragraph 43 finds the effect of Article 22 is to preclude reliance on Article 10 of the directive in relation to actions which have been begun before the coming into force of the directive. Now, the important point for my distinguishing this case is that is not the appellant's submission today. The appellant's submission is not saying that the damages directive applies retrospectively to their claims. It wasn't our case below, it's not our case here. We're making a different argument, namely that the cessation requirement is mandated by the general EU general principle of effectiveness. And so there is no consideration, understandably, in the judgment of Mr. Justice Simon, of either the EU principle of effectiveness or the cessation requirement. That was not how the argument was run. Paragraphs 44 to 48 go through the particulars of claim. There's then the chronology, and at paragraphs 93 to 110 is Mr. Justice Simon's central analysis and conclusion. And in Shorty found that the necessary facts were in the public domain before the limitation dates.
Where are you?
Starting at paragraph 93. Had a discussion. At paragraph 93, second sentence, the claimant's case was that there were 4 key facts which were neither discovered nor discoverable with reasonable diligence. And at paragraph 94, for the reasons I've already set out, this is no answer. Next sentence, the claimants have not identified any such facts. On the contrary, the defendants were able to demonstrate by reference to the chronology set out above how the particulars of claim derived from material which was available before the limitation dates. And then at paragraph 101, I accept the full picture was not available. However, the lack of information on the issues identified does not mean the particulars of claim are defective as a matter of form or analysis. In other words, the claimants, this is now me speaking, had satisfactorily pleaded their claim, which showed they knew enough about the facts. Paragraph 105, current proceedings were not brought following the discovery of some new fact relevant to the rights of action. And so Mr. Justice Simon granted the card scheme's strikeout summary judgment applications. That's at paragraphs 107 to 110. So no mention of the general principle of effectiveness, no mention of the cessation requirement at all. This was solely a case concerning section 32(1, the Limitation Act 1980, and whether the claimants had sufficient knowledge to plead their claim. And I have taken you to that case because I submit the Court of Appeal decision has to be understood in that context. And I would turn now, if I may, to that Court of Appeal decision. That is at Authorities Bundle 3, tab 40. Starts at page 902. Now, before we dive into it, you will recall that the card schemes, in this case, say that you're bound by this judgment to determine ground 3 against us, and they say that the Court of Appeal determined as binding ratio, first, that all the English limitation rules as set out in the Limitation Act were compatible with the EU principle of effectiveness, and second, that the cessation requirement found in Article 10.2 of the Damages Directive was, quotes, new law, unquotes. And I will say, first, that is not what Arcadia says. The Court of Appeal in Arcadia did not determine the issue that is now before you, namely whether the cessation requirement was mandated by the general principle of effectiveness. That's not what was being argued. And that's no surprise, because they didn't have the benefit of Volvo or Eureka to ground their arguments. And second, in any event, any comments in Arcadia concerning the cessation requirement, I will say, were overture. Now, that case was concerned with section 32(1, the knowledge of facts. It was not concerned with the cessation requirement. So this case was heard in 2015, and the judgment of the Chancellor, then Chancellor, was handed down in August 2015, very shortly afterwards, of course, well before Volvo and Eureka. The judgment starts at bundle page 904, and we see at paragraph 1 the appeal by the claimants on the card schemes that, 1, the claimants are not entitled to rely on section 32(1)(b) of the Limitation Act, and the claims are statute barred. So that's the subject matter of the appeal. Now, if you're lucky enough to be reading this in colour, by the way, any red sidelining is by MasterCard, any green sidelining is by Visa, and our sidelining is black.
Well, we haven't got that benefit.
I'm afraid,
Hard copy, and whatever it is that Opus 2 are doing, they're not doing for the judges, that's for sure. We don't have any transcript of any description. We don't have access to the documents online through the Opus system at the moment.
I would certainly try and ensure that you get access to the transcript.
But it's not the
whatever
first
form.
time, in my experience, where Opus have let this court down.
I'm afraid I'm also, as it were, watching in black and white, because I'm just told about these colours. I haven't actually seen them. In the
I've
hard
got
copy.
colours. I've got a PDF with lovely colours.
Oh, well, there we are.
Oh, well,
Should have relied on my own computer and not the Opus one, shouldn't I?
your lordship is privileged that way.
But we're never given a key as to what the colours mean, so we have to guess that.
You might have to repeat it.
I,
I know yours is black.
The red is Visa, right?
MasterCard is red.
Who's the green?
Green is Visa.
Because I noticed that the sidelining in Jacobs, which we got this morning, was in green, and that explains why.
Yes.
Thank you. So whose is the sidelining against paragraph 1 of the Court of Appeal judgment in Arcadia?
Well, I don't know, of course, because I
It's
only
red,
have black and
it's
white.
red,
It's red.
But apparently it's red. So
MasterCard.
that's MasterCard's.
No.
Paragraph 2, through to paragraph 7, the Chancellor set out the background to the claims, and then at paragraph 8, just by G, critically, for the purposes of this appeal, the defendants contend that in any event, the claims for damages sustained more than 6 years before the issue are statute barred.
Yeah.
Paragraph 10, the claimants contend that the limitation period in section 9 has not yet expired, and indeed has not yet begun to run, by virtue of section 32. In other words, again, section 32. The High Court judgment is summarised from 16 to 29, and at paragraph 20, that is MasterCard sidelining, that's the damages directive point. The judge held that the damages directive is inapplicable to the present proceedings. That is so. But it is irrelevant to us. It is not the appellant's argument in this appeal. And in this passage, the Court of Appeal also set out at length the findings of the judge concerning when the claimants had sufficient knowledge, and so on, because that's what the case was about. Paragraph 30 is then side-headed discussion, again, section 32(1)(b), and at 30, the court said the first ground of appeal is that the judge wrongly applied the statement of claim test. And the Chancellor explains why he rejected that ground of appeal at paragraphs 31 to 49. In particular, at paragraph 49 is the statement of claim test, which I don't propose to read out because it doesn't matter for us. Again, 32(1)(b). At paragraph 50, the claimant submitted these principles did not apply to competition law claims. That's rejected at 51 to 52. And at 53 to 72, the Chancellor explained in detail why the statement of claim test was met for those claims well before the limitation dates. And I won't trouble you with the detail of that. Suffice it to say that at paragraphs 53 to 62, the relevant facts are analysed for the purposes of section 32. They haven't been concealed. Paragraph 63 to 71, the claimants prayed in aid comments from various other domestic cases to get around the strict and narrow approach of the statement of claim test. The Chancellor dismissed that. And the conclusion is at paragraph 72 here. It follows as a matter of domestic legislation, the judge was correct to hold any period earlier than the limitation dates of statute barred. Now, the remainder of the judgment, which is the part that the card schemes rely on heavily, has to be viewed in that context. So far, everything has been concerned with section 32(1)(b). The section on page 920, starting limitation EU jurisprudence, starts, the claimants submit that on that interpretation. So in other words, in relation to what has just been said in paragraph 72, there is a new and different submission. The question is, at paragraph 73 to 76, addressed to that question, but still section 32(1)(b) only, because that was the issue before. So when you look at all of that follow, 74, 75, all the bits that the card schemes rely on, it is on that interpretation.
Sorry, on what interpretation? So the claimants submit that on that interpretation, what does those words refer to precisely?
They refer to the previous section, which concludes with paragraph 72, the previous section that is entirely about section 32(1)(b) and the test that's addressed in paragraph 49, which is whether a fact relevant to the plaintiff's right of action is available, facts which improve prospects are available, facts bearing on a matter not a necessary ingredient.
But what's they got to? I don't understand that, because on that interpretation is simply what he's actually done in the preceding 72 paragraphs is apply English law to the facts of this case.
Yes.
And say the judge was right. There's no knowledge that they didn't have, and therefore limitation ran.
Yes.
So on that interpretation is not really relevant, because the submission is that the domestic law of limitation contravenes and has to give way to the EU principle of effectiveness.
If that is the English law of limitation,
It's the English law as
which it
applied
is,
here.
then what's being argued here is if that's the English law of limitation, then it contravenes the principle of effectiveness. And the Court of Appeal goes on to decide that that is not the case, that the principle of effectiveness is not contravened by the English law of limitation. And that's the bit that's relevant for present purposes and binding on us.
Well, the reason I say,
It's clearly not obiter.
it's not obiter, but the reason I say that it doesn't apply to you here is because on that interpretation refers only and exclusively to the arguments around section 32(1)(b) and knowledge.
No, I'm afraid that's just a nice try, but that's not how this reads. The question is whether the principle of effectiveness means that the English law of limitation contravenes that principle. This decides that it doesn't. The English law of limitation remains exactly the same as it was in Arcadia. The Court of Appeal has decided it doesn't contravene the principle of effectiveness. What you're trying to do is to say, oh, well, now there's some later European decisions that I can rely upon and say, well, now it would contravene the principle of effectiveness, therefore decide the case differently from the way in which it's been decided by this court previously. That's what it comes to.
Yes, but in my submission, the principle of effectiveness is always going to be fact sensitive. So they've looked at the principle of effectiveness for the purposes of knowledge in section 32. They haven't looked at it at all in the context that we're looking at it here, the cessation requirement for present purposes.
They do go on to do that, don't they? Because at 77, they refer to the Damages Directive, Article 10, and they say that shan't have retrospective effect under Article 22, and that is a good indication that the Damages Directive does not merely give effect to existing jurisprudence. I consider that it is plain that they are new law.
And I'll submit how I propose to get around that.
So, okay.
So if we start, we'll just take a step back. Paragraphs 73 to 76 first, before we get to your 77, which I promise I'll get to shortly.
No, I'm sure you will.
They're addressed, again, to that question, that interpretation, section 32(1)(b). No cessation requirement. So paragraph 74, the Chancellor explains how domestic limitation periods are perfectly consistent with EU jurisprudence, provided it does not make the recovery of compensation practically impossible or excessively difficult. That is, of course, with respect, a correct statement of the EU law principle of effectiveness. And I add in parentheses that the CJEU in Volvo and Eureka, still unseen, but we know what it says, has shown that the recovery of compensation is practically impossible or excessively difficult as a matter of EU law, where limitation begins to run while the competition law infringement is ongoing. I have yet to come to that. But that's not here, and it doesn't matter because it wasn't this case. At paragraph 75, we say, I see no good reason why the barring of claims in respect of any period prior to the limitation dates in the present proceedings should be held to be an infringement of the EU principle of effectiveness. In the present proceedings, quite rightly, with respect, confined to Arcadia. And his lordship then goes on to explain why claims could have been brought earlier, addressing only knowledge again. And then the final sentence in paragraph 75, there is no basis for concluding that a limitation period of 6 years for a competition law claim with the benefit of the postponement provisions in section 32(1)(b) of the 1980 Act is in principle incompatible with the EU principle of effectiveness. And I don't know, but I bet that that is sidelined heavily in red and green by the other side.
You've won that bet.
These broad comments are entirely grounded in section 32(1)(b) and the facts of this case, of Arcadia, and when the claimants could have brought a claim. That's not what the appellants are arguing here. At paragraph 76 is a sort of an amusing interlude. Mr. Randolph had referred to a case called Danske Slag Terrier. That was a case, we didn't turn it up, it's now in the Supplementary Authorities bundle, I see. That was a case about a directive on pig meat that gives off, I quote, a pronounced sexual odour, unquote. It has none of the special features of a competition law case and cannot be read across, and the court, unsurprisingly, so found. Can't see there's anything.
What did you decide about this odour? In the actual facts, why? I mean, just what did you decide, Danske?
Danske did decide that the limitation period was adequate. The Danish, I imagine, limitation period was adequate. That the point about the odour was that if meat gave off such an odour, it had to be destroyed. Somebody said it wasn't properly transposed and it caused them loss. If you want to look at it, it's in Supplementary Authorities Bundle 4, tab 4.
But it was presumably suggested in that case that the limitation period was not compliant with the EU law principle of effectiveness.
Yes, because the National Court had held that under national time limits, the case was barred, and what the case found was that it was compatible with community law. We see that in the head note, page 75 of the supplementary bundle. Compatible with community law to lay down reasonable time limits for bringing proceedings in the interest of legal certainty, protected the taxpayer and the authorities. And such time limits were not liable to make it in practice impossible or excessively difficult.
Yes, but the important thing for this purpose is that in that, I take it CJEU, not General Court, is it?
It's a General Court.
General Court, is it?
No, it was
it's the Grand Chamber.
Grand Chamber.
Grand Chamber.
Just the Grand Chamber.
It was being suggested that it was not compatible with the principle of effectiveness to lay down specific limitation time limits in domestic law. And So it was a point that was argued. I don't know whether it was also argued that there had to be a cessation requirement.
It was not. The case simply wasn't about competition law, and therefore wasn't about cessation of an infringement.
Well, I mean, it could be cessation of a smell. I mean, I don't know. I haven't read the case, but I'm not sure that when we're making a really in-depth analysis of what the Court of Appeal was deciding in Arcadia, and they refer to a case which does indeed, in the Court of Justice, deal with the principle of effectiveness, we can just gloss over it and say it's about pigs, it's about competition.
Well, that's what the Court of Appeal did.
But well, maybe they did, but we have to look at what it did decide, because that will give us some indication of what was being argued.
Yes, well, what Danske Slag Tjera did, that's the right way to pronounce it.
It's about slaughterhouses, I expect.
I imagine.
Danish slaughterhouses, they kill a lot of pigs in Denmark, a lot of bacon. Yeah.
It was, and you'll see the sidelined part in red on page 131. Which
131.
131 of the Supplementary Authorities bundle, internal page 370 of the Common Market Law Report. They cite at paragraph 50 the judgment in Manfredi, which is a pre-Brexit judgment that the CJEU also relies on in Eureka.
Yes.
And at 78 and 79, it says, of Manfredi, the court held it is conceivable that short limitation period that runs from the day on which an agreement or concerted practice had been adopted could make it impossible in practice to exercise the right to seek compensation for the harm caused by that prohibited agreement or practice, because Manfredi is about such practices. The court stated that where there are continuous or repeated infringements, it is thus possible for the limitation period to expire even before the infringement is brought to an end, in which case it would be impossible for any individual who has suffered harm after the expiry of the limitation period to bring an action.
So you see, don't you, that the argument about whether or not the infringement had been brought to an end was in that case.
But then it's distinguished in the next sentence. However, that is not the situation in the main proceedings. So they say this is not a Manfredi case. It is clear from the order.
Manfredi, maybe.
It is clear from the order for reference that the limitation period at issue in the main proceedings, so in the Danske Slag Tjera case, cannot begin to run until the injured party has become aware of the loss of damage and of the identity of the person required to pay compensation. In such circumstances, it is thus impossible for a person who has sustained loss or damage to find himself in a situation in which the limitation period begins to run, or indeed expires, without his even knowing that he has been harmed, as could have been the position in Manfredi.
So where's Manfredi 78, 79?
That's in volume 7, tab 73. So before we jump to Manfredi, and I will jump to it almost instantly, just to nail down Danske Slag Tjera, it's another knowledge case, not about the cessation requirement at all. If we look at Manfredi, which is at which tab 73 of Bundle 7, you'll see from the headnote that the Italian Competition Authority and subsequent courts determined various insurance companies, including the defendants, had, contrary to Article 2 of Italian competition law, participated in an anti-competitive agreement relating to civil liability vehicle insurance by inter alia exchanging information which had enabled the participants to charge large increases in premiums that were not justified by market conditions.
And jumping ahead, we see in paragraph 79 and 80 that it was suggested there that the EU law principle of effectiveness prevented the limitation period expiring because, or should do, because the infringement had not been brought to an end.
That's right. And I positively rely on that.
Yes.
I hope it's sidelined in black.
Please,
Because...
and red, you'll be pleased to hear.
Good, well, we're in agreement.
Sort of.
So, 78, a national rule under which the limitation period begins to run from the day on which the agreement or concerted practice was adopted could make it practically impossible to exercise the right to seek compensation for the harm, particularly if that national rule also imposes a short limitation period.
Yeah.
Now, this squarely a competition law case, unlike the Danish pigs case.
Mm-hmm.
In such a situation where there are continuous or repeated infringements, it is possible that the limitation period will expire even before the infringement is brought to an end, in which case it is impossible for any individual who has suffered harm after the expiry of the limitation period to bring an action. Now, that is a foreshadowing of what is then also concluded in Eureka, and we've come to it backwards, but the Advocate General in Eureka, Advocate General Cocotte, says that in her opinion, this case, Manfredi, is perfectly transferable to the facts of Eureka.
Well, it gives one of the slightly, what should we say, finding a nice word, slightly nuanced answers at 81, because it said it's perfectly open to the domestic legal system to prescribe a limitation, provided the principle of effectiveness is adhered to.
Slightly circular, really.
Can we just go back, and maybe you're going to do this, to what is actually said in 79, because
Yeah.
I find it, speaking for myself, quite difficult. The last part, in those circumstances, it's impossible for an individual who's suffered harm after the expiry of the limitation period to bring an action. Well, doesn't that make assumptions about the domestic rules?
Well, it does. It refers to the national rule in paragraph 78, where the limitation period begins to run from the day on which it was adopted, and then, not unlike the English system, continues
but
day on day.
I realise that, but looking at the second half of 79, is that actually a fair description of the effect of the English system? Because, of course, if you bring your action early enough, you can effectively, typically, carry on amending it to update it for ongoing damage. So what is the problem under the English system? I appreciate that the Advocate General in the later case takes this and runs with it and possibly goes somewhere else with it, but at the moment I'm just trying to understand this statement in the context of the English system.
So what happens is you have an infringement, and we say in the present case that the infringement started as long ago as 1992.
Indeed.
You've got no idea it's going on. If limitation starts before the infringement has ceased, and indeed begins to run on every day on which the infringement takes place, there are actions, rights of action, that keep falling off the end of the limitation period, right up to the present day.
But why has
But
it
you
been
do the
impossible?
infringement. I just don't understand that solution with respect. Because under section 32, unless you have knowledge, and put it in very broad terms, it's obviously more complicated. Unless you have knowledge, time is suspended. So none of this actually, as a matter of English law, none of 78 or 79 is relevant, because that's not English law. This is talking about the fact, if you've got a short limitation period without a knowledge provision that suspends it, then I fully understand the point that if the infringement is still continuing and hasn't ceased, then you might find yourself in a situation where your claim was time barred without you knowing it. But where you've got section 32, then and a decision of the Court of Appeal that says that with section 32, English law limitation complies with the principle of effectiveness, then it seems to me none of this is relevant, but there we are.
Well, the knowledge that the Court of Justice talks about isn't exactly the knowledge that we're dealing with in relation to Section 32. But what the Court is saying in the second part of paragraph 79 is in fact, I submit, crucial to understanding how both the Advocate General and the Court see the principle of effectiveness in relation to time running.
But on the facts of this case, why has it been impossible to, under domestic rules, to bring an action in the case of an individual who's suffered harm after the expiry of the limitation period? I mean, the later harm is more susceptible to being caught by being
within time.
Yes, exactly. So
And the
I
earlier
really have
harm
to-
is covered by Section 32
Yeah.
on this assumption.
So I can understand, as the Chancellor says, that there may well be limitation systems of law where this is a concern, because the chance to bring an action has gone away before the infringement is ended. But that's not how the English system works.
But we'll see when we come to Eureka that in fact the Czech system works in a very similar way, and the Court of Justice found it didn't meet the
Well,
principle of
that's why I said the Advocate General may have taken this comment and gone somewhere else. But I'm trying to, as I said, trying to understand this case at the moment.
So what they say in this case is that if you cannot claim for any part of your loss, then you haven't given the full effectiveness that the principle of effectiveness requires. That's the logic of when the Advocate General in Eureka looks back to the previous case law, and I might dip into courage in a moment, of the Court of Justice of the European Union. And when she then comes to the conclusion she comes to, she is seeing the full effectiveness of EU law as requiring that you must be able to claim for all of your loss. That's what's being said in the second part of 79. And my learned friend, Mr. Otti, wants me to read on. And of course, as I think has already been said from the bench, there's then quite a sort of vague reference to whether it's for the National Court and so on. But this is an ECJ judgment from almost 20 years ago. The ECJ, in my respectful submission, used to be rather more subtle and rather more respectful of the national courts in saying it is for the national court to determine whether a national rule that does all of these things meets the principle of effectiveness. In more recent judgments, viz. Eureka, the court has, whether impatiently or more confidently or otherwise, started simply to say, no, this doesn't meet it, rather than sending it back to the national cases. But it has identified in these earlier cases an issue as to what is the full effectiveness of EU law. And the three cases in particular that the Advocate General in Eureka cites are Crean, Manfredi, and Kogiko. And we see, for instance, in Courage and Crean, an old case, well, 2002 case, which is at tab 72 of Bundle 7.
Yeah.
That was a beer tie case.
Sorry, which
yes.
bundle?
Same bundle, tab 72.
Mm. Yeah.
What we see in this case, I won't trouble you too much with the facts, but it was one of those cases where a pub had a beer tie agreement with a brewery, was found to be anti-competitive, And at F on page 2240, we see English law did not permit a party to an illegal agreement to recover damages from the other party. The defendant's claim to damages would, as a matter of English law, be barred, even if his Article 81 defence was successful. And one of the key finding is at 2255, paragraph 26, and the court found the full effectiveness of Article 85 of the treaty, and in particular the practical effect of the prohibition in Article 85.1, so this is the forerunner of Article 101, would be put at risk if it were not open to any individual to claim damages for loss caused to him by a contract or by conduct liable to restrict or distort competition.
So which paragraph?
26. Now, as usual, the ECJ speaks in a slightly oracular fashion, but as has been identified in subsequent cases, where the ECJ speaks of the full effectiveness of Article 101 and the principle of effectiveness, it means not only that you have to be able to claim in principle, as was in issue in the Courage and Crean case, but also in full from the beginning. And that's been traced through the case we were just looking at, Manfredi, and traced through in a similar way the case of Kogiko.
Is that the third of the cases you
That's
mentioned?
the third of the cases. That's at tab 76, starting at page 2360. And in Kogiko, one sees in the headnote that it was a damages action brought after the date of adoption of the damages directive, but before the deadline for its implementation had passed, and governed by national procedural rules already in force. And the court, the Portuguese court, ruled that a national procedure providing that a 3-year limitation period which started before the injured party was able to ascertain the identity of the infringer and which could not be suspended or interrupted during proceedings before the National Competition Authority rendered the exercise of the right to claim compensation practically impossible or excessively
Sorry, which paragraph is that?
difficult. It's the headnote.
I know, but which paragraph?
H3, just below the second hole punch.
There's very few electronic hole punches.
That's because the relevant Portuguese limitation law didn't have a provision like Section 32.
Well, it didn't have a slightly different sort of provision, which was to suspend limitation while the Commission was investigating.
No, it's not the point. Making the point that it says in terms there, providing for 3-year limitation period which started before the injured party was able to ascertain the identity of the infringer, which couldn't be suspended during the proceedings. So the point that's being made there is if, well, it seems to me at least, if the Portuguese law had provided for the suspension of the period of limitation until you were able to identify, had the relevant knowledge, knowing constat that it would be held it didn't comply with the principle of effectiveness.
Broadly, yes. Although I will say that it's a slightly different kind of suspension. This is the sort of suspension you get in competition law cases, where you suspend during the investigation or the appeal before the competition authority. But in essence, it was about this limitation period expiring before you had knowledge.
Yeah.
And we see the Advocate General at paragraphs 81 to 83, page 2375, saying that, agreeing with the Commission at 81, that national rules on limitation must be assessed as a whole, and emphasising a national rule such as the Portuguese one that does not merely restrict the limitation period of 3 years. It's notable the limitation period begins to run regardless of whether the injured party is aware of the identity or not, and then points out no suspension or interruption during ongoing proceedings before the National Competition Authority. The fact the limitation period begins to run without any knowledge as to the identity of the party, as well as the lack of provision for suspension or interruption during proceedings, are, in my estimation, capable of rendering the assertion of claims for damages under antitrust law excessively difficult, says the Advocate General.
Yeah. And
the court then says in relevant part, well, various things, but I'd like to go to page 2386. Paragraphs 45 and following, as limitation periods constitute detailed rules governing the exercise of the right to claim compensation, it is necessary first, in approving the Advocate General's opinion, to take all elements of the Portuguese rules into consideration. Second, account must be taken of the specificities of competition law cases, and in particular of the fact that the bringing of actions for damages on account of infringements of EU competition law requires, in principle, a complex factual and economic analysis. In those circumstances, then, it must be stated that national legislation laying down the date from which the limitation period starts to run, duration and rules for suspension or interruption of that period must be adapted to the specificities of competition law and the objectives of the implementation of the rules of that right by the persons concerned, so as not to undermine completely the full effectiveness of Article, in that case, 102 TFEU. The same applies to Article 101. So it is, again, to be appreciated that when the court talks about completely the full effectiveness of Article 102, in this case, it was entirely out of time. The same would apply if any part of it would be out of time. And if we look over the page 2387, there are two more paragraphs of relevance to us. At 52, the court says, the appropriateness of a limitation period, having regard to requirements of the principle of effectiveness, is of particular importance, both in respect of actions for damages brought independently of a final decision of a national competition authority, and for actions brought following such a decision. With regard to the latter, the limitation period, which starts to run before the completion of the proceedings, following which a final decision is made by the National Competition Authority or by a review court, is too short in relation to the duration of these proceedings and cannot be suspended or interrupted during the course of those proceedings. It is not inconceivable that that limitation period may expire even before those proceedings are completed. In that case, any person suffering harm would find it impossible to bring actions based on a final decision, finding an infringement of EU competition rules. Now, it's still about knowledge to some extent, but we are also now shading into the same thinking that underlies the cessation requirement. Very often, once the proceedings are completed and an infringement has been found, it ceases. Usually, the conduct stops there. So this is at least related to the cessation requirement, and no doubt that's why the General and the Court in Eureka look back at Cogito and say, well, here's one of the cases. And then 55 is the conclusion of all of that, which repeats the finding. Important about Courage and Manfredi and Cogito, I'm sure this is already appreciated, is they're all pre-Brexit cases. So those are all uncomplicatedly binding on this court. My submission is that even if Eureka is not binding, it is perfectly open to this court to reach the same conclusion as the Court of Justice in Eureka reached by the same route, namely by a pre-Brexit case law that's also relied on by the Advocate General and the Court of Justice.
Well, we could if we weren't bound by Arcadia.
If you're not bound by Arcadia, and that's my prompt, because all of this, all of this excursion into Korean and pre-Brexit case law was prompted by the remark around Mr. Randolph's pig case in paragraph 76 of Arcadia. And we have, as it were...
And the reason why that's important is because if you look back at Arcadia now, which is at tab 40, and you look at those paragraph 78 or whatever it is, we can see that a reference to Danska Slakteria included a reference to Manfredi. Because if you read Danska, you knew about Manfredi.
Yes.
And what the court says, knowing about Danska and by implication Manfredi and the new legislation, was, we think, that makes the damages directive still new law, and that our limitation process, including its knowledge provisions and its failure to import a cessation requirement, is compliant on those principles with the EU law principle of effectiveness, which you say it now definitely isn't. But that's what it was then.
But in relation, in this case, in Danske, in relation to a non-competition law case, the cessation requirement would have been meaningless in relation.
Danske was, I mean, but the court's seized of the point because it's got Article 10 and Article 22 in mind. It's considering whether Article 10 and Article 22 reflected existing EU law, and it's saying no, it isn't, and therefore the EU law point that was being raised, which is that our law is not compliant with the EU law principle of effectiveness, is rejected. Now, you may say it wasn't very well argued and it's all could have been much clearer and so on, but that does seem to me to be what those paragraphs are.
Well, 78 is absolutely plain, isn't it?
Yeah.
Well,
because it hasn't even got a black line by it, Mr. Mason.
I'm sorry about that. But,
Well, you can't like it, then.
Well, 77 and 78 taken together are flatly contrary to submission you're addressing to this court.
Well, it's the next section. So we've got as far as Danske in 76, but after 73 to 76, in my submission, if one reads this, that's the end of any consideration of the general principle of effectiveness. It's only those 4 paragraphs. So they consider the first EU law submission that is made concerning the general principle of effectiveness, but they're solely concerned with issues of when claimants had sufficient knowledge, because it's the context of section 32(1)(b, the Chancellor recalled in the earlier part of the judgment. They don't consider the cessation requirement, and the Chancellor then moves on to the second submission of my learned friend Mr. Randolph at 77. Mr. Randolph submitted, that's the other submission, in the context of infringement, the relevant EU law principles as to limitation periods are laid down in the damages directive, which he said merely codifies long-standing EU jurisprudence, or even though it was enacted in 2014. And he referred to some recitals.
Well, the cessation requirement. The argument was that the cessation requirement represented long-standing principle of EU law.
They do,
and that's what he was addressing, and that's the submission that's rejected.
They do concern the cessation requirement, but, and this is the crucial point here, only in the context of the damages directive being retroactively effective, and not as a general principle of EU law. It's not mentioned, the argument about the general principle of EU law, as it is in this case. So what's an issue in this case, I say, is not an issue in Arcadia, which mentions the cessation requirement, but it does not address it as a binding general principle of EU law.
Well, what does it mean by merely codifies long-standing EU jurisprudence? And that's the whole point, isn't it?
Well, at 78, they say, as the judge rightly concluded, that provision is of no assistance to the claimants. Article 22 provides expressly that domestic legislation to give effect to the Damages Directive, which doesn't have to be transposed into national legislation until 2016, shall not have retrospective effect. That is in itself a good indication the Damages Directive does not merely give effect to existing jurisprudence. I consider that it is plain that the provisions of Article 10.2 in particular are new law. But there is no consideration of the case law in relation to the general principle of effectiveness, because it wasn't necessary. It was only an argument about the retrospective effect of the Damages Directive, which we say is not this case. So I can see that we're not in agreement on this.
Well, no.
But those are my submissions on why I say you can distinguish. You can
distinguish Arcadia.
And it was, as I say, a case about Section 32. I should probably come back, my lord, on your lordship's remark to me about, well, what's the problem if you have Section 32? But there is a difference between the knowledge requirements under EU law and Section 32. Your lordship's point was that Section 32 ought to be enough to render English law effective, as we can't be timed out for lack of knowledge. But with respect, that point perhaps proves too much, because in our case, we do not say we're relying on Section 32. The existence of MIFs, of merchant interchange fees, was not secret. No. We didn't know the details of the unlawfulness. But the answer, with respect, can only be Eureka, where Czech law was similar to UK law, and where no knowledge was in issue. We say our case is like Eureka in that way. Okay. Otherwise, without being cute about it, otherwise we wouldn't be here.
So, you want us to look at Eureka?
Yes. So, just as it were, to round off what I've been addressing you on so far, because of the way we've come at it, quite rightly, your concern is Arcadia. I've addressed ground 3 and Arcadia, and I've addressed it in 2 ways, which is that I say you can distinguish Arcadia, and my other way, it will recall, is that I say you have a statutory way in to getting around Arcadia. And the statutory way in is through sections 4 through to 6 of UWA 2018, which I say gets you back to all of those powers that existed before Brexit, when dealing with a supreme matter of EU law, and therefore I say we are back in a situation where the doctrine of precedent is not applicable. We have cited in our skeleton argument my Lord Justice Flo as Mr. Justice Flo, as you then were, in Byrne and the motor insurance.
My goodness me, that's a long time ago.
Yes.
It's the first trial I did as a High Court judge.
It is. Can we just turn it up briefly?
I was very green, unlike the sidelining.
It's
where you write.
It's at Authorities Bundle 3, tab 36.
2007.
Yep.
It was a claim against the Motor Insurance Bureau, and what had happened was that the claimant's application had been...
Sorry, which tab?
Rejected. It's tab 36, page 823.
You are to be congratulated for your electronic page numbers matching reality.
Yeah.
Thank you. Your solicitors.
A rare coincidence.
Well, it's
Yeah.
the second case in a row that I've been involved in where that's happened, and it makes a fantastic amount of difference to the time the case takes.
Yeah.
Brilliant.
I'm sure that will go down very well with those behind me.
Well, I'm in it too.
Yeah. Okay.
It was a case where it was said that the United Kingdom had failed to implement the Motor Insurance Directive correctly, in that the victim of an untraced driver had not been able to obtain protection equivalent to or effective to one who was insured. And that was indeed so held by the learned judge. We see that in the head note at 1. At 2, there was a principle community law whereby the national courts of a member state were obliged to apply a broad approach in interpreting domestic legislation in order to achieve so far as possible the result intended by a community directive and thereby complying with community obligations. But, there isn't a but there, but that was not applicable in that case because the slightly idiosyncratic way in which this had been implemented by the UK was as a private law agreement between the insurers and the state, so that couldn't be leasing. And then at 3, over the page, it was held that although Directive 84/5 was capable of having direct effect, the Motor Insurance Bureau was not an emanation of the state. Your Lordship may recall, this may start to feel familiar, that in the case of Lewis, I appeared before your Lordship, then already as Lord Justice Flo.
Yeah.
Your Lord Justice Flo had regard to a later European Court decision called Farrow and Whitty number 2.
Yes, I do remember that.
And departed from Mr. Justice Flo
Yes.
on that point.
Yeah.
And that's by the by. The relevant bit is quite short. It's at paragraph 56,
56.
of page 843. The first part of 56 is about the discretion having been fully used. That was in fact confirmed in Lewis. But then at the bottom, the last 2 lines of 843, the obligation to apply the principles of community law as laid down by the European Court means that the doctrine of precedent is not applicable. Citing, I think that's a different decision in Crean.
Yeah.
And my explanation earlier on about the effect of that is that is preserved by sections 4 and or 5 of EUA in the way that I've explained. And so the usual rule of precedent set out in cases like Young and Bristol Aeroplane, which my learned friends rely on, from the 1940s, unsurprisingly, doesn't apply to...
Well, it doesn't apply, absolutely. I mean, it doesn't apply if the Court of Justice has held that the previous precedent was wrong. When I put Kemford to you earlier, that's a case about res judicata, I think, so that's not actually directly applicable. But the point that we're faced with here is that Brexit has intervened, and the Court of Justice decision is for us, is a decision to which we, quote, may have regard, not a decision which binds us anymore. And unless you're right about your interpretation of 4, 5 and 6.
Yes.
Yeah.
But I
And
recognise...
the whole point about Bern is that that was when we were still in the in the European Union, and I make the point absolutely clear that I was bound by the Section 3.1 of the European Communities Act to apply the principles of EU law. And
I
if
mean,
that
it would
was
have
right,
been
then
pretty
we could-
uncontroversial then.
I think it was perfectly normal, wasn't it? And we don't have Crean an entrepreneur in the bundle, I don't think, but my recollection is it was a pretty straightforward point.
I'm sure it said what it says it said.
Yeah.
I recognise all of that, and I recognise what my Lord the Master of the Rolls says to me, which is that I need the UWA 2018. But that, in my respectful submission, is the point of UWA 2018. It's your
You
UWA.
might be able to say, don't you, that by one route or another, Volvo and Eureka are binding on this court in the same way as they would have been binding on this court pre-Brexit, if they'd been decided pre-Brexit.
No, because you don't have to decide the way Volvo and Eureka.
As I understand it, what you're saying is that the words have regard, or may have regard, should be interpreted in the light of the other provisions of the Act as enabling us to have regard and follow despite normal domestic rules of precedent. In other words, as conferring a, if you like, broader power
Discretion.
than we would otherwise have.
Yes, exactly, because of the operations of sections 4 and 5. So section 6.2 is about precedent. It means that you don't have to follow it as a precedent. You're not bound by it. But you can have regard to it. Which, what does that mean? You don't just have regard to it, forgive me for being flippant, but out of curiosity or interest. It is the way in to finding that as a matter of EU law, and, see Miley, as a matter of EU law at all material times, the rule was, as stated now, as it happens, in Eureka. Whether you reach that through Eureka, or you reach the same conclusion as Eureka via Crean and Manfredi and Codico, for instance, makes no difference. You come to the conclusion that this is what was EU law. This is how EU law was to have operated at the time. And then you are within sections 4 and 5. And
then we may have a genuine res judicata problem. Of course, you say you're not bound by Arcadia, which decided EU law wrongly, as we now know. I'm assuming in your favour that you're right about Eureka. And you say, even though the issue was the same in Arcadia, because your clients were not parties, even though the defendants were, it doesn't bind you.
Yes.
So not a question of precedent now, but a question of issue estoppel.
Yes, we're not issue estoppel. We weren't in Arcadia.
No, but there are authorities about third parties being bound by certain, I'm not quite sure how far they go. But this is the same issue because it's all about MIFs. So why doesn't it bind you? I mean, let's assume there's millions of claimants out there affected by MIFs, and the court decides some very important principle point about it, which I think my lord and I did a few years ago. Doesn't that bind everybody?
Well, not in these circumstances.
Well, I mean, you're going to have to persuade me of that a bit, because my understanding is just because you didn't opt in if it's a class action. I mean, I can't remember who the parties were to the Arcadia litigation.
I have a feeling, but it's no more than a feeling, that the Arcadia litigation was one of the claims that was before the court in the Sainsbury's appeal. Because Arcadia rings quite a bell.
Yes, Arcadia was
We
a
had
party.
both MasterCard and
We
Visa,
had
but in
Master-
separate
yeah.
proceedings. It was Sainsbury's against Visa, Sainsbury's against MasterCard, and I think Arcadia
I can
against
look that up.
Visa. And one of the things was that two of the cases had been decided in the commercial court, which of course Arcadia was,
And one in the cab.
albeit by a different judge. It was at a later stage of the proceedings, I think, when it had gone on further. Have we got Sainsbury's in the bundle? There's no reason why we should have, I don't suppose.
Give me a moment. The parties are listed, for what it's worth, on page 136 of the supplementary bundle, the judgment of Mr. Justice Simon.
Yeah.
There's 12 parties. None of them, as far as I'm aware, any of the claimants here represented today. It wasn't, with respect, a collective action. It was just a private action brought by 12 undertakings. So we didn't have a way in to Arcadia, even if we'd considered it.
I don't know. I mean, my recollection is a little bit like my lord's about the big MIF case that the Supreme Court heard. I'm just going to see if I can find it.
2020.
I mean, I think I'm assuming that this court was upheld by the Supreme Court on the material findings. I think it was.
Mm.
Well, I think they got permission to appeal. I don't think it went. I don't think there was, in fact, an appeal, even if permission was given.
From
Arcadia.
no, but we're talking about that Arcadia, in subsequent parts of the litigation, Arcadia was consolidated with the case of Sainsbury's, which I now can't find. What was the other name?
Sometimes Sainsbury's, Morrison's were involved. Sainsbury's, Morrison's, Sainsbury's.
Well, let's try these. Yes, MasterCard final hand down. So, okay. So this was Sainsbury's against MasterCard, Asda, Arcadia, Argos and Morrison's versus MasterCard, Sainsbury's versus Visa and the European Commission. But Arcadia is crossed out. So I suspect Arcadia discontinued
That's right.
before it got to us.
But if you look at
Our judgments in 2018.
the Court of Appeal judgment at page in the summary at the beginning of page 903, by claim form dated 23rd of July 2013, the claimants, Arcadia Group brands and others, Asda Stores, Comic Group, Debenhams, House of Fraser, etc., William Morrison Supermarket and Argos. In other words, those are the same, it's the same litigation at a later stage, but Arcadia had dropped out.
I'm instructed that you are right, my lord, unsurprisingly.
Yeah.
That's why you don't see the name Arcadia.
Mm.
But in my respectful submission, it doesn't make any
I
difference to
understand
my
the point you're making, I'm just trying to clarify.
Well,
Yes.
I mean, you say it doesn't matter, but I still would like to be satisfied. I mean, all these issue estoppel cases tend to merge. We seem to have it every week at the moment. And I would like you, please, with your juniors, to take a little time just to show me why, if this decision was made in a case, I don't know whether the merchants were parties to the Arcadia litigation, but why you couldn't or shouldn't have been, because it's all at the same time, isn't it? It's the same case.
But the merchants weren't part of that.
Same list, isn't it?
They weren't. I mean, yeah.
Well, these merchants weren't.
No, these merchants.
These merchants.
No. Where's it?
But I mean, this case is Arcadia, which is a merchant, against Visa.
But we'll look into the issue of estoppel point. My simple point, unless and until I'm corrected, is that my clients weren't part of that case. They might all be merchants, but so are many parties. I can't improve on that point. We'll look into third-party issue estoppel and give more chapter and verse when we can.
I mean, you can't just go on litigating the same point because another merchant pops up and says, I want to run the point again. I mean, at the very least, we're going to look at the previous decision and say that should be very persuasive, if not binding.
Well, something has happened, and the something that has happened is Volvo and Eureka. And so it may...
Well, no, Eureka, or however it's pronounced, took place after you started these proceedings.
Yes. But
Anyway,
Volvo
okay.
So,
Just answer another question, if you can, Mr. Moser, what I got in my mind. What happened to the Merrick's bit of this litigation that was before the CAT? The usual Mr. Merrick's as class rep on behalf of 46 million lucky Brits who will get the benefit of £7.50 each some date in the very, very distant future.
as he said. Well, I'm going to let my learned friend Mr. Wolf answer, who is in fact in two courts at once.
Yes, so the merits case is ongoing before the Competition Appeal Tribunal. There was a trial on the issue of pass-on.
Is that what the pass-on trials is?
That's on about, and the Competition Appeal Tribunal at the moment. And the issue is effectively what loss was borne by the merchants in their claim period, and what loss.
But the Merrick's claimants didn't appeal to this court the decision of the CAT on this issue.
On the cessation.
On the cessation point.
No, I mean their claim was entirely. So that they did bring another appeal. I'll let others answer. I'm not here representing Merrick's, obviously, but for Merrick's, their claim was a follow-on action from a European Commission decision that covered the period 1992 to 2008, and therefore it related to matters that already had long in sense ceased before. But they were not concerned with the cessation requirement.
Right, got you.
They weren't concerned with what?
They weren't concerned with the cessation requirement in the same way. They did appear at the hearing below. They did join in with it. They were actually pushing more of it than the knowledge requirement.
Okay.
Well, Mr. Otti can help us on that if we need help.
I would have something on my mind as well. You said at the beginning that there's a specific part of Lipton, namely the fact that everybody thought that this was not a binding, an authority binding on us, a binding on them, post-Brexit. And I would like you to write down what you concede for the purposes of this appeal on a piece of paper, please, so that the other side can see whether that is a sufficient concession to dispose of the argument in that, because otherwise our judgment would have to get into it and explain why we didn't think we would contribute to the debate, which will all be lengthy and time-consuming and a waste of time. So if you could write down in a sentence what you said to us this morning, but carefully worded with the appropriate references, that would be extremely helpful.
I'm happy to do that.
Thank you.
It's largely based on what my learned friend Mr. Otti put in his supplementary
I know what it is, but I'd just like you to write it down, not Mr. Otti.
Yeah.
We will do that.
And then Mr. Otti can say whether he's happy with that. And we can move on back to Arcadia again.
Yes.
I mean, we've got the argument now that you put forward. The argument that I would personally seek a little more clarification on is the way you construe section 4, 5 and 6. The point my lady really put to you about have regard to. I mean, you know, I may be very naive and only been involved in 500,000 EU law cases, but I always understood that legislation, when it says you may have regard to be a politician's way of legislating to say you don't have to follow. Those words, have regard to, mean
May have regard
you may
to.
have regard. I mean, Tune-In is a classic case where they tried to get, you know, it was the first case where they tried to get us to overturn EU trademark law, I remember sitting with Lord Justice Arnold, who, in his judgment, did a masterly analysis of every EU law case since time began, and we decided that we would not overrule EU law on that point. But I mean, my understanding was that have regard to, as I say, it was a very clear cipher, but don't need to follow if you don't want to. Now, I don't really understand sufficiently clearly why how 4, 5, and 6 interrelate. So it would help me if you could just say that a little bit more clearly, so I understand exactly how you get there. I don't want to record it, you know, I may, it's better to really understand it.
Yes, so I'm glad to do so. At some point I will come to Eureka.
Yes,
But
I mean, we're assuming for the purpose of this argument, Eureka says what you say it says.
Yes. So the argument in relation to sections 4, 5, and 6, if we go back to Authorities Bundle 1, tab 12, page 190 is section 6 of U1.
Don't you normally start with legislation at the beginning of it?
Well, yes, but I wanted to pick up my Lord's point around...
Because 6.1 says is not bound,
yes.
and 6.2 says may have regard. So the contrast is important, right?
It is. The way your Lordship has characterised it with respect is exactly correct. You do not have to follow post-implementation completion day CJEU judgment. But I say using the same paraphrasing, you may follow or apply, if there's a difference, post IPCD CJEU judgment. Looking at section 6.1, a court or tribunal is not bound by any principles laid down or any decisions made on or after IP completion day by the European Court, and B can't refer. 2, subject to this, and subsections 3 to 6, a court or tribunal may have regard to anything done on or after IP completion date by the European Court, another EU entity, or the EU, so far as it is relevant to any matter before the court or tribunal. If the court determines, therefore, that Eureka and Volvo are relevant and has regard to them in the present case, why is that? It is presumably because the court considers that they correctly state general EU law principles as they applied prior to Brexit. And if the court is persuaded that Eureka and Volvo correctly state the relevant general principles of EU law as they were in force at the relevant time, then that has the following consequences. First, the cessation principle, as presented in Eureka, is an aspect of the principle of effectiveness and/or of the principle that Article 101 should be fully effective. That's Eureka 52 to 55. Second, if we turn to page 185 of Bundle 1 and section 4 of U1 2018, I'm going to say that those wider principles are undoubtedly principles which fall within section 4 U1 2018. Because if we look at it, saving for rights, etc. 1, any rights, powers, liabilities, obligations, restrictions, remedies and procedures which immediately before IPCD are recognised and available in domestic law by virtue of Section 2 of the old Act, and are enforced, allowed, and followed accordingly,
Yeah, I see.
continue on or after IPCD to be recognised and available in domestic law, and to be enforced, allowed, and followed accordingly. So those wider principles of effectiveness fall within the broad rubric of rights, powers, liabilities, obligations, restrictions, remedies, procedures, which immediately before IP completion day were recognised and available in domestic law.
And we didn't know it.
By virtue of Section 2.1 of the ECA 1972.
Yeah.
So, and if you're looking for Section 2.1 of 1972, it's in Bundle 1, previous tab, but I think we all know what it says.
So, I mean, it's terribly simple, really. It's Section 4.1 and 5.2, which once we decide that Eureka expressed a pre-Brexit principle of law, EU law, that was the EU law, and if we decide to have regard to it, we don't have to, but once we do have regard to it, because we think it's an EU principle of law, it's applicable by 4.1 and 5.2, and we are bound by it.
Yes.
And it overruled Arcadia. Arcadia was inconsistent with it. And if you're wrong about Arcadia, it still doesn't matter. So if Arcadia really did decide incorrectly as a matter of EU law, it doesn't matter because that's a matter of precedent, not a matter of issue stock.
Yes.
It's a matter of precedent, which is simply wrong, and CJEU takes precedence, so that decision was just wrong. And if it had been argued on the 1st of January 2016, you'd have said, well, there's a principle of EU law which Arcadia didn't take account of, and that trumps it, so you ignore it, Arcadia.
Yes, because the general principles in Section 4.1 continue to be recognised and available in domestic law. And I don't even need, as such, to get myself into the wording of Section 5.2, but that is, as it were, not only but also where the point is we fall within Section 4 and supremacy already applies, but supremacy is also set out expressly in Section 5.
Yes, but you do have to come within rights, powers, liabilities, obligations, restrictions, remedies, and procedures. Which is this?
I would say both a right, well, both is the wrong word, all of a right, a power, a remedy, and a procedure. We're entitled to our remedy in damages. We're entitled to we have a right to the procedure which was enforced, allowed, and followed before, as reflected in my Lord Justice Flo's judgment in Byrne. And the intention of the Act, I submit, is that where supremacy applies, the doctrine of precedent, which is about how the courts identify what the law is, let me take a step back.
So I've written down that is a right, power, remedy, or procedure, and/or procedure arising under the proper application of the EU law principle of effectiveness as interpreted in Eureka.
yes, so the principle of effectiveness, my lords, is
a
an aspect.
long-standing, proper application of a long-standing EU law principle of effectiveness as interpreted later in Eureka.
Yeah, and that's an aspect of a right to a remedy under Article 101.
A right, power, remedy and procedure under Article 101.
Yes. And that, in my submission, is of a piece with how the intention, what the intention was, that where supremacy applies, the Act meant it applies in the same way as it did before Brexit. And there's the explanatory memorandum to the Act, which is referred to in the skeleton argument somewhere, but it's in Authority Bundle 8, at tab 88, at page 2596. That talks about Section 5 and supremacy.
What are we looking at?
It's the explanatory notes
Oh, yeah.
to the Act, the UR Act. 2596 is a reference to supremacy at paragraphs 100 and following. And it's 103. This is essentially indicative, but I say it helps. 103, where a conflict arises between pre-exit domestic legislation and retained EU law, subsection 2, it's 5.2, provides the principle of supremacy of EU law will, when relevant, continue to apply as it did before exit. So, for example, retained EU regulation would take precedence over pre-exit domestic legislation that is inconsistent with it. The principle would not have to be relevant to provisions made by or under this Act to other legislation made in preparation for exit. The principle of supremacy also means that domestic law must be interpreted as far as possible in accordance with EU law. So when we're talking about domestic law, I say we're talking about the entire body of domestic law, including precedents and so on. So, for example, it continues, domestic law must be interpreted as far as possible in light of the wording and purpose of relevant directives, and so on. So, I pray that in aid of my interpretation of both Section 5 and Section 4, and the application of supremacy post-Brexit once the courts have identified what they say EU law actually is. So, hence the distinction I sought to draw at the beginning, and it was put better with respect by my lady than I put it, but the distinction between the doctrine of having to follow in 6.2 and being entitled to follow. And of
So
course,
your first step is, you say, determine what EU law is, and when we're doing that, we presumably have regard to what the CJEU said in the
Yes.
most recent cases. But we could, in theory, I think you say, decide that actually they got it wrong
yes,
and EU law was something different.
yes. Indeed, and we see that in a case called Tower Bridge that my learned friend relies on. That was the VAT case. Yeah, that's right. No, it's the VAT case about. Well, we can come to it later, but yes, so it's open to the court to say no. I think they got it wrong, and
Who's they in this context?
the ECJ,
Court of Justice.
Court of Justice. But if the court says, no, we think they got it right, that is EU law, then that leads us back to what, with respect, I said was the illogical conclusion advanced by the other side. That even though the court considers that Eureka correctly states EU law, it should nonetheless regard itself as bound by Arcadia to reach the contrary conclusion. Or indeed, that you're reading into section 6.2, that you have to do that where you're not otherwise bound by existing national authority. As I said, that's not what section 6.2 says. And I submit that the reason it doesn't say that is because of the operation of section 4 and the power this court has to depart from previous authority of coordinate jurisdiction, because we're dealing with EU law as preserved by the Act.
Does it come to this? Your case is that the only way is that the effect of Eureka, and you would say the other cases, back to Manfredi, is that the only way in which the principle of effectiveness of EU law under EU law can be satisfied in competition cases by a limitation period, which both includes a knowledge provision and includes a cessation provision.
Exactly.
So that's the only way in which the principle of effectiveness can be satisfied.
Put it in a slightly different way, a rule that does not allow for a cessation requirement and a knowledge provision will not satisfy the principle of effectiveness. I don't know whether that makes any difference. That's how I've
putting the same point the other way around.
I think so. I think that's just how I've put it before. And that's because that's
basically
EU law.
The previous Chancellor was wrong to say that that was new law.
Even though he referred expressly to the cessation requirement.
Yeah, but he was wrong. And if he's wrong, he's wrong, and we don't apply what's wrong.
Yes, and to his, in his defence, it wasn't argued in precisely this way before him. And I've tried to explain why the argument was perhaps a little diffuse in that sense, because it was grounded in a dispute around section 32. The cessation requirement came in, as it were, by a side wind in the Court of Appeal. So there might have been some fogginess around the cessation requirement that didn't bring it into focus in the way that it is in this case.
And you say that goes with the grain, anyway, of English law, because we put damages directive into English law from 2017 and actually have not repealed that even now.
Indeed. That is the current law. And looking across the piece on a more policy basis, it is also the law that applies to those claimants who are based in the EU. I mean, claimants in this case. You'll have seen that there are claimants in Austria and Sweden and other parts. For them, the applicable law is national law, national competition law, as read through EU law, including, of course, Eureka. So there will be claimants in this case who have EU law, as it ever was, if it's a matter for the application of applicable law under the conflict clause. And it would be further inconsistent if the UK claimants and the EU claimants somehow had a different version of EU law applied to the very same case in the very same proceedings. So both of those points, I say, point in favour of preferring this matter. I don't know whether it assists at this point to touch on cases where the UK courts have followed and where have not followed to complete, as it were, this section. I note the time. I would like to come to Eureka and Volvo at some point, but probably because it's been heavily trained, I can be relatively brief about that. But there are...
So what if we think Eureka is ambiguous as to whether it's a pre-existing principle of EU law?
I would, I'm sorry, facetious answer. I would respectfully say it could hardly be clearer. I think maybe
let's go to Eureka and then you can mop up Tower Bridge and all that later.
Yeah, let's do that. And
Eureka as well.
Eureka is at. Give me, I won't just look at where I am. Well, Eureka it's in tab. It's in volume 7 of the authorities book.
Tab 81, 2480.
Great. Now, much of this ground has already been traversed now. This is, of course, as has been pointed out, it's a judgment that comes after the date of the capture. We say, nonetheless, it's to be had regard to. It should be noted the progression of this instant appeal was stayed by consent in order to await the hand down of Eureka, so that it could be addressed in the party skeletons. And in my
so what could be addressed?
Eureka.
Oh, this case.
This case, yeah,
this case was stayed so that
we waited.
Yes.
For Eureka.
You perhaps had a little hint of what was coming.
Well, if we look at Eureka at 81, Eureka is a Google shopping case. That's the finding of abuse involving Google's search engine. Google, of course, well-known company. They are dominant, indeed super dominant, in the area of general search engines on the internet. And it was found by the Commission that they had leveraged their dominance in the general search market into the market of comparison shopping services. Comparison shopping services are a particular kind of search service on the internet. There were a large number of these. Most people went first to Google, and what Google did was they did two things. They promoted their own comparison shopping service by way of a box at the top of the page. If you said, I search for sneakers or whatever, you get a little box with Google comparison shopping at the top of the page. And they demoted other comparison shopping services that were in competition with their comparison shopping service, and said to have caused them loss. And one of those companies is Eureka. And they brought an action against Google for compensation for damages for this conduct. And under Czech limitation rules, it was found that at least partly Eureka's action was time barred. And if we look at 248 of the head note at H3, the last sentence, according to the referring court, under Czech law, a 3-year limitation period ran separately for each instance of harm, subject only to knowledge of the harm and the party causing it, and the period might not be suspended or interrupted during a commission investigation, nor until 1 year after the commission decision becoming final. And we see what was found, head note 5. There's a nod to it being for the legal systems of member states. 1, 2, 3, about 9 lines down, the sentence starting, it followed. It followed from that principle even before the expiry of the time limit for transposition of Directive 2014, national law laying down the date on which the limitation period started to run, the duration thereof, and the rules for its suspension or interruption must be adapted to the specificities of competition law and the objectives of implementation of the rules of that law by the persons concerned, so as not to undermine completely the full effectiveness of Articles 101 and 102. And we know, of course, from our pre-reading that not to undermine completely the full effect is drawn from co-geco, which is duly cited there. And they also follow Volvo. I suppose the headline of that section might be Mr. Randolph was right, because that's one of the things he argued in Arcadia. Then limitation periods. H6, Article 102 TFU produced direct effects. The full effectiveness of that provision, and in particular that of the prohibition laid down therein, would be questioned, especially if, owing to national law fixing the date on which the limitation period started to run, duration of that period, and detailed rules for its suspension and interruption, it would be practically impossible or excessively difficult for a party to claim compensation for harm caused to it by the abusive conduct of a dominant undertaking liable to restrict or distort competition. They say it is apparent from case law that that right would be rendered practically impossible or excessively difficult. And again, if it began to run before the breach came to an end, and the injured party did not know or could not reasonably have been expected to know the information necessary to bring its action. And that is at paragraphs 53 to 55, which are worth looking at in the original. And a further reference to limitation periods is at headnote 8. There is also the question of knowledge necessary at headnote 9, but that concerns us less in our case. Starting with Advocate General Cocotte's opinion in Eureka, this starts at page 2487. The Advocate General unequivocally supported the existence of the cessation requirement as a binding rule of EU law, and she grounded that conclusion in specific features of competition law and in previous case law. In particular, we see the cases that I've already referred to. If we turn to page 2504, starting at AG 97, there's a reference to two cases, the case of Volvo, which I'll come back to this afternoon, where the court found, in relation to a situation governed by national law predating the directive, that the limitation periods laid down in that national law cannot begin to run before the infringement has ceased. And I say this, as it were, in parentheses. The cat below approached Volvo in a very, in my submission, overly technical way, which is to look at what was absolutely necessary for the dispositif, the last bit of the conclusion of the court, and then only had regard to the bits that it considered were so necessary, and finding effectively that the cessation period was not ratio. We see that the Advocate General, and in due course the Court of Justice, has no such difficulty, and indeed does not approach the interpretation of its own judgments in that way. And I will say, when I come to Volvo, and I come to the judgment below, that much of the error flowed from the fact that there was, shall we say, a heterodox approach to the interpretation of Court of Justice judgments. An approach that our researches appear to show is unique. We haven't found a similar approach in any previous UK judgment, and certainly not in an EU judgment as we see.
But anyway, you've
So
got...
the approach of only having regard in terms of ratio to the dispositif,
Yes. And
not to the underlying reason.
But anyway, you've got Manfredi, which is interpreted by Eureka as already stating the law 20 years ago.
Yes.
And you say, I mean, just coming back to your main point, you say you really ought to have regard to what the law was before Brexit. Even if you, as a matter of discretion, you could say somehow, for some reason, well, we're going to ignore it, and we have a free hit to decide what we think EU law ought to have been. That would be inconsistent, inappropriate in the light of the fact that it is now very clear what EU law was all along, and Arcadia got it wrong.
Yes.
Irrespective of whether Arcadia had good argument or not, you say it's now pretty clear, and it would be perverse, I think you'd go so far as to say, not to have regard to what is obviously the law, and was the law.
Yes.
And it's our own principle of the law being, decisions simply being declaratory of the law, when it's a principle of general application.
Yes. As it is in Luxembourg.
Yeah.
And the Advocate General's opinion strongly supports that. And in cases like Eureka, where the court expressly follows its Advocate General, it is, in my submission, not only permissible, but also important to look at what the Advocate General says. And this was put in a somewhat eccentric way, perhaps, but I've already cited it, by Mr. Justice Jay in one of the MIB cases, where he said, in Luxembourg, where the ECJ sometimes speaks in an oracular fashion, the exegesis has to be found elsewhere. And the exegesis, in this case, is the Advocate General.
Is the
Advocate General.
Advocate General.
The Advocate General's
Oh, I
opinion.
see. Well, that's perfectly permissible when the Advocate General is concurred with.
Indeed. And
So, provided it's clear that the court has followed the Advocate General's opinion. Because
yes,
it doesn't always follow it completely. Sometimes it follows it only in a narrow way.
Not at all.
But I mean, that's not this position, is it?
I say absolutely not. The court follows the Advocate General. They are ad idem, and in various places, the court says, as the Advocate General noted.
Yeah.
In particular, paragraph 63 of the judgment,
Yeah.
in relation to the cessation requirement, the court and the Advocate General are ad idem. As the Advocate General noted in point 118 of her opinion, cessation of the infringement as a condition which must be satisfied in order for the limitation period to begin to run may have a deterrent effect and lead the perpetrator of that infringement to bring that infringement to an end, and so on.
Is there any disagreement with Visa or MasterCard about what this decision actually says?
Yes,
There's
I think
some
there
nodding,
is.
yes.
There is.
There isn't.
So I fear I'll have to take you through it and tell you what I say.
Yeah, no, it's fine.
So we might be able to finish the Advocate General before
Okay.
lunch. She then refers to Manfredi and saying the court held that a national rule under which the limitation period for bringing an action runs from the day in which the agreement with certain practice was adopted could make it practically impossible to exercise the right to seek compensation. Well, you've seen what Manfredi says. The Google and the Commission say, like the schemes perhaps, that can't be transposed into the context of the present case. And there is also the new law argument raised. If we look over the page of 2505, Advocate General 103, she's still reciting the arguments of the other side, and 4 lines down, they argued the directive established an entirely new legal reality. But AG 104, that line cannot, however, be accepted. And at 107 and following, she sets out why. First of all, it is based, well, not the argument, the right is based on a right arising from the full effectiveness of Articles 101 and 102 TFEU, capable of not only providing a remedy for the direct damage, but also for the indirect harm, the structure of the market. It was not able to reach full economic efficacy in the shopping cases because the shopping comparison sites weren't able to develop their business as they should have been. Actions for damages for infringement of EU competition rules are an integral part of the system for enforcement. And we see cited in the footnotes cases such as Courage and Sumar. And the same is then expanded on at paragraphs 108 to 112. I won't read them all out now, but they you can read them. They go through the arguments that I have been taking you to in Kogiko, in Manfredi. It's also, I mean, they're not the only pre-Brexit judgments mentioned. There's other judgments like Skanska and so on mentioned there, but we don't need to look at all of them. We see what the Advocate General says, they say. And the finding at AG 116, or the opinion at 116, is accordingly, is over the page, enforcing a limitation period in respect of an injured party solely on the basis of that party's alleged knowledge of the infringement is a source of legal uncertainty. By contrast, the twofold requirement of knowledge and the end of that infringement allows the starting point of the limitation period to be determined precisely and reliably, in particular in the case of actions further to a decision of a competition authority in the interest of the injured party and the infringer. It would be cynical to enforce a limitation period against an injured party whilst the infringement is still ongoing. You could hardly be stronger. Moreover, the requirement 118 that the infringement has ceased for the limitation period to begin to run may also result in the infringer bringing the infringement in question to an end sooner. And importantly, I say, at the next sideline bit 123 to 124, it follows from those considerations that to enable the effective exercise of the right to compensation, and thus to satisfy the objectives of the enforcement of the rules of competition law by injured parties, the limitation period for bringing an action for damages must not begin to run before such an infringement has ended. Contrary to the arguments put forward by the Commission and Google, the ratio, obviously I pause on that word, the ratio underlying the judgments in Volvo and Manfredi is therefore perfectly transposable to the present case. Accordingly, the third question, point one of the fourth question, should be answered to the effect Article 102, read in conjunction with the principle of effectiveness, precludes national legislation which allows the limitation period for the right to compensation for harm caused by anti-competitive conduct to begin to run before that conduct ceases entirely. So not only do we have, again in parentheses, the Advocate General's opinion that the ratio of Volvo certainly does include the cessation requirement.
Might be a good moment for you to finish for lunch.
But also,
ringing in our ears.
Indeed.
Paragraph 124 of Advocate General Cocotte.
my lord.
2 o'clock.